Every day in the USA, people find themselves in court.
They sent it.
Wayne? No, just the attorney is here.
Oh, okay, no.
Okay. Counsel Frank. Sir, you need to unmute.
Good morning.
Okay, it would be, last name would be Foley.
No.
No? Okay, Counsel Frank, just
Yes.
giving you a heads up, is that we have not received anything from the city of Wayne.
What do we do? I mean,
It's up to the police or to whoever's in charge of the case to submit the file.
we're respectful.
So that there can be a probable cause hearing, or if it's just an arraignment. But we have not received anything, sir.
Respectful, Your Honor. He was picked up at 2 o'clock in the morning on Monday, 2 o'clock in the morning. He could have been arraigned anytime Monday. He could have been arraigned anytime yesterday. And here we are an entire day later, Christmas Day. His wife is sitting here on Christmas. I mean, this is, in fact, I offered yesterday by phone. I said, you know, I will go and represent to the police department and the prosecutor that I will make sure that Mr. Foley appears in court, that there is no problem. I am in the bar journal. 51169. I've been a lawyer in the state. I've been a lawyer in the state since 1994. I've been a lawyer since 1987. There is no reason that the state of Michigan or anybody else has to fear that Jonathan Foley will have any use. They have laid out good money to for me. There is no reason for anyone to fear that Jonathan Foley will abscond. Okay, and he's sitting here stewing with his thumb in his ear. Okay, and there is no reason why Your Honor does not have a file in front of her. Okay,
Okay.
I think this thing
There
should.
may be no reason. Counsel Frank, you can say everything that you want. It is on record, but I can't do anything because that file has not been submitted. It has to be submitted either for just an arraignment or submitted for a probable cause hearing. And if there is probable cause, for an arraignment.
Well, can we do this, Your Honor? Can we at least have him? Can we at least have him released?
You see, sir, you're asking. I don't even know who to call. Who is the officer in charge? Who is to do this case? I don't even know if you made calls to the city of Wayne. All I can tell you is that from my court officer, we have not received anything. And you were the first people that have been on Zoom, and I've told you that I haven't received anything. We waited for the clerk, and I've asked the clerk, do we have anything from the city of Wayne? And it is no.
You've been very gracious, Your Honor. I've been sitting here for 2 hours, and as has his wife. The phone number for the police department is 734-721-1414, option 2. You'll be in charge. You'll be in touch with the police officer in charge. They'll confirm that they have custody of Mr. Foley.
I don't have a file. I don't know who would be doing the probable cause or anything like that. It is up to the city of Wayne. It is up to the officer, whoever is in charge, whoever has the file to provide and to submit it to the court.
And they tell me that the Wayne County Prosecutor's Office is supposed to be conducting this hearing with me and with Your Honor. Now, what are we supposed to expect?
No, for all I know is that there is no warrant out for his arrest other than the file may be with the prosecutor's office. I honestly can't tell you. I have no knowledge. I don't know what the charges are. So I don't know the process in terms where the file is.
Well,
has it been authorized by a prosecutor or not? I do not know, sir.
Fair enough. Then, given that there's no warrant for his arrest, can Your Honor at least order that he be released right now?
No, because the court doesn't have jurisdiction as to that. I don't have a file. I can't order that, sir.
He's being held without charge. There's no file. There's no file. There's no nothing. This is what is going on here, Your Honor?
I can't tell you that, sir, because I don't know what is happening in the city of Wayne. I do not know what is happening with the police department.
Can we at least, can I at least ask Your Honor to?
Oh, no, you can call them, sir. I have a number of cases that I'm dealing with. Okay, if I have a file, I contact somebody.
I have done that only about 3 or 4 or 5 times this morning. And they tell me that as of 10 o'clock this morning, they were supposed to present this person for an arraignment in front of Your Honor via Zoom
Okay, well, I have no file, sir, so I can't tell you that, what's going on. I don't know if the file is with the prosecutor's office. Prosecutor's office is reviewing it. Whether they're going to authorize it or not. Can't tell you.
Is there a prosecutor assigned to Your Honor's courtroom? Is there a
No,
name
sir.
and a number? Is there a name and a number that I can call?
No,
So there's no.
no, I don't have any Wayne County prosecutors assigned to this courtroom, sir.
So there's no prosecutor and there's no police officer that I can call.
No, you can try again, the police department, find out who is the officer in charge of the case, see what happened. Maybe they are waiting for the prosecutor's office to authorize a file from the prosecutor's perspective.
That is what they've
So-
only told, with great respect, Your Honor, that's what they've told me about 4 or 5 times, and we keep getting absolutely nowhere. And so now with great respect, I'm speaking to the one person with authority, and this one person with authority refuses to help me. I'm asking Your Honor.
It's not me refusing to help you, sir. I don't have a file. So I can't tell you anything more than that.
So without a file, this person, there's no charges pending against this person. And so
I don't know that. I don't know if there are any charges or not. I
I
don't know what is. I understand you can place everything on the record, sir, but I have no file.
My frustration is this, Your Honor. I've only presented about 2 or 3 dozen people for probable cause conferences who have been outside of custody. And I've walked those persons into courtrooms, okay, for arraignments and probable cause conferences, and those persons have been, they started the day off with their wives and their husbands, okay? They started the day off in their homes, okay? And that's all I ask, is that this person start the day off in his home with his wife, okay? That's all I ask, is that this guy start his day off with his home, in his home with his wife. That's all I ask. I'm not asking that, I asked a second ago that the charge be dismissed. All right, don't dismiss the charge, okay? Let's just set him up for an arraignment on a different day. Let's postpone the arraignment. Let's set him up for an arraignment on a different day, and I'll bring the gentleman in for an arraignment on a different day. That's all I ask. That's all I ask.
Sure, but you're asking something that I have no control, because it is up to the district court to present the information to this court. We haven't received anything from the city of Wayne.
Can we not adjourn the arraignment?
Sir, there is no arraignment. There is no probable cause hearing. I haven't had anything because I have no file. I have no case file. I have no charges. I have nothing.
We haven't even heard from Wayne today.
So-
Wayne hasn't even called.
So you can try calling Wayne, see what's going on. I don't know if they're gonna let him go or not. Honestly, don't know, sir.
How long?
I was just doing you a courtesy, Council Frank, letting you know that we have not received anything. We have not received any calls or anything from the city of Wayne.
How long will Your
Either
Honor?
the city of Wayne or the police department from Wayne.
How long will Your Honor be on the bench?
I'm on the bench until I finish.
All right, I will be back in touch with Your Honor. Thank you.
You have a good day. Try to have a good day. Thank you.
I said I should help. Hello.
Is Meti?
Yes.
Is Sufi? And this magistrate at Chortea. I'm just giving you a
Yes.
heads up. I still been checking if a file from Wayne, the city of
Mhm.
Wayne, has been submitted. Has not. If they
Okay.
have not, that means that they have not submitted jurisdiction. Okay,
Okay.
in order to do that. So I just wanted to let you know.
Thank
okay,
you.
as to
Thank you
that.
so much.
I was gonna tell you also your, the attorney, Counsel Frank, let him know the same thing. Nothing is, just before, I brought you in from the waiting room. I asked my clerk and they've also told me, nothing has been submitted from the city of Wayne.
Okay. Thank you so much
Okay.
for all your help. Is it okay if I keep on waiting in the waiting room just in case something happens? And then,
You
if
can, but
you-
the deadline, I will say this, ma'am, the deadline was at 10:30 for any
Okay.
files to be submitted.
Mhm.
But I was hoping that maybe something would have been submitted. Don't know what the charges were. I would have looked at it, but nothing's been submitted, ma'am.
That's completely okay. Okay, then do you think that the best course of action is just to leave the meeting and then wait until tomorrow? Or is there still some hope that?
It could be that the city of Wayne is not subjecting this file to the 36th district, that they want to do it tomorrow. I honestly don't know, ma'am. I have
Okay,
no other information. Sorry about that.
it's completely okay. It's not anybody's fault. Thank you so much for everything though.
You know what, why he was arrested?
It was on so he was riding a dirt bike
No, no.
home.
Was this drinking and driving?
No,
Okay, all right, then
No.
I don't know, ma'am. Okay.
Yeah, that's okay.
Sorry about that.
it's completely
All right.
okay.
Okay.
Thank you.
Yes, ma'am.
Can I still wait?
Oh, shoot. All right, if she comes back
You
in,
don't need to wait, Joe.
you know, I know, but maybe she wanted to see something else. What's your full name, sir?
Good morning, my name is Arraignment Johnson.
Thank you. Mr. Kegler Johnson, I'm Magistrate Chartea. You here on a criminal matter, case number 240-6119301. You have an attorney. Go ahead, counsel.
Thank you, Your Honor. Randall Upshaw on behalf of the defense. We waive the formal reading, stand mute to the charge.
Thank you. I'm going to enter a plea of not guilty. Court dates are January 7th. Oh, hold on. We need to get the attorneys for the prosecutor's office, the city. I don't know who is coming on today. Let me see. Let's see. Counsel Byrd,
Yes, Your Honor.
can you call one of the defense counsels? One of the prosecutors, because nobody is checked in.
I don't have their number, Your Honor.
Okay, can you ask your coworker? Ms. Kismeti?
Yes, I'm so sorry if this is annoying. But I just heard that my husband called me and said that an officer told him that he did get charged. So I don't know
Okay.
if
The thing is, let me say this so you understand.
Mhm.
It's up to the district court to subject themselves to 36th District Court to do any arraignments and probable cause hearings. Wayne
Mhm.
District Court or anybody on behalf of Wayne District Court has not submitted a file, okay, on behalf of your husband.
Okay,
They may want to do this matter tomorrow.
okay,
I don't have any further information.
okay. Well, then
Okay.
I will leave you to your day then. Thank you so much for
Thank
everything.
you. No problem, ma'am. Bye. Council Ragnan.
Your Honor, I could not get a hold of the only person we get a hold of out of the four of us who do arraignments is myself. At my daughter's here today.
Okay,
I don't.
I appreciated that you're coming here, so I'll let you know what the charges are, okay?
Okay. Be fine.
Okay, thank you. All right, so we're gonna start off with, this is Mr. Kegler Jackson. Please say your name again.
Good morning, Your Honor. My name is LeBron Taylor Johnson.
Thank you, Mr. Kegler Johnson. This case number is 240-6119301. People of the State of Michigan versus Mr. Kegler Johnson, who is charged with count 1, assault with intent to murder. Count 2, assault with intent to do great bodily harmless murder by strangulation. Count 3, weapons fired discharge in or out of building causing injury. Count 4, carrying concealed weapon, motor vehicle. Count 5, 6, and 7, each count is weapons, felony, firearm. The date of offense is August 29, 2024, in the city of Detroit on Young Street. Counsel Upshaw, waive
Yeah.
former reading, stand mute.
Yes, Your Honor.
Thank you. I'm gonna enter plea of not guilty. Court dates are January 7, 2025. Probable cause conference followed by preliminary examination, January 14th, 2025. Both matters are in front of Judge Giles. Mr. Kegler Johnson, let me tell you some bond conditions. 1, you're not to possess any firearms or any other dangerous weapons. 2, you're not to have any contact with Latigo New Stackhouse. That means no person-to-person contact, no contact with third parties, no phone calls, no emails, no text messaging, and you're not to go back to the location of 13995 Young Street, City of Detroit. You understand those bond conditions, sir?
Yes, ma'am.
All right. Counsel Ragnan, I'm not sure if you have access to the investigator's report or not.
I do not, Your Honor. I have.
Okay, then I'll let Counsel Upshaw go with his argument first.
Okay.
Good afternoon, sir. Merry Christmas.
Very
Yeah.
good.
Mr. Ragnow, this is a third time my client was charged with this offense. This offense occurred back in August the 29th. He was arrested. We went to the preliminary exam. At that time, there's a no-show. The case was dismissed. He came back. The judge gave him a $500,000 10% bond. We held the PC. We held the preliminary exam in front of Judge Taylor. Judge Taylor heard the witnesses, heard the police officer.
Hi. Isn't this supposed to be working today? Sorry.
And
Who is?
case for insufficient probable cause. He was released.
Hi, Lisa.
You should mute, but
I apologize. It's my coworker, I think, supposed to be working.
Okay, I see her. Counsel Douglas is just bringing her in from the waiting room.
Okay, I'll sit, Lisa. Thank you. I was online.
Okay.
Very
Counsel Douglas?
apologetic. Hi, Jennifer. Merry Christmas.
What are you doing here, Mr. Ragnan?
I just thought
Standing in, I appreciate it.
Well, Merry Christmas to everyone. I apologize for interrupting you, Mr. Upshaw, in your argument, but I will not.
enjoy your holiday.
All right. Merry Christmas. Thank you, Jen.
Thank you. Merry Christmas. And Counsel Douglas, we've already gotten past. This is on Kegler Johnson. Do you need the court dates, ma'am?
No, Your Honor.
Okay, we did bond conditions, no contact with the complaint New Stackhouse, no firearms. It's not to go back to the Young location, Young Street location.
Okay.
So Counsel Upshaw, please state your argument again for the benefit of Counsel Douglas.
Now, my understanding, I believe this is the third time this case with me representing him was brought up. My memory is clear, and it's unclear on the first time, but I think it was dismissed because there was an insufficient witness that didn't appear. I know I conducted, then rewrote. He was given a $500,000 10% bond. He was released on that bond. He appeared up at the PC. He appeared at the preliminary exam while on bond. The case was held for the Honorable Judge Taylor. Witnesses, police officers, and others took the stand. After hearing the preliminary exam thoroughly, the case was dismissed because there was insufficient evidence. At that point, because he was on bond, that was it. I thought if they want to reinstate it, which I didn't think they would, but they would have gave me a call. They didn't. They came, they seen him, identified himself as Mr. Johnson. They arrested him with no problem. Judge, based upon these facts, I would ask the court to give him a nominal bond because he'd been appearing, or at the worst, reinstate the $500,000 10% bond that he never got back. That's still in the system. It was posted by Detroit bail bonds, and he posted the $500,000 10%. Now I would ask the court to allow that bond to stand because he never missed a date.
Thank you. Counsel Douglas.
Your Honor, while it's true that Mr. Keeler Johnson never missed a date, and this is the third the third issuing of this case. As Mr. Upshaw says, the first one, there was a police officer witness who failed to appear. With that first case, the bond was 500,000 cash or surety, which was kept at redetermination, dismissed September 23rd, and then it was reissued September 23rd, but the new arraignment was September 25th. And like Mr. Upshaw says, you actually did that arraignment and you ordered a 500,000 10% bond, which was kept at redetermination. Here we would note that there was new evidence included in this new investigator's report, which would lead us to actually ask for the 500,000 cash or surety. Your Honor, I did check the file notes to try to see what the insufficient evidence was. Mr. Upshaw has the benefit over me because there's nothing in the file notes that indicate what happened at exam. But what the new evidence is that on December 17th, lab results came in for the blood that was found on the firearm that was recovered near the scene, and that the DNA from that firearm matches up with Mr. Keegler Johnson, which is evidence that was not available before. So, Your Honor, we do think that this is strong evidence that Mr. Keegler Johnson was in fact the shooter, given that this shooting is allegedly on video. Your Honor, we do have concerns about safety. That's why we are asking for the 500,000 cash or surety. But like Mr. Upshaw says, this is the third time it's been charged, and he has shown up for court.
Thank you for the representations, both sides, this particular matter. This court was not aware that this was the third time. Nobody gave any information when we did the probable cause hearing that it had been a reissue matter. This court doesn't recall any of that. However, what this court is going to do is going to give him $500,000, 10%. And we're going to mark it as, okay, unaffordable.
Excuse me, Your Honor, if I may.
Okay, the reason I'm making it unaffordable so that he gets a court date for this Friday. If he does not make the bond, if he does make the bond, then he doesn't have to go to court this Friday for the bond redetermination hearing.
No, what I'm asking is this. This case was just recently dismissed. The court still has his $500,000 bond there on stand. He didn't get any bondsman didn't take it back. Anything.
Well, I can't, Counsel Upshaw, I can't, that's on another case. So I can't take that bond that is on another case.
Even though it's the same, just different case number now, you can't use that?
Yep, different case number. Oh, counsel, what can happen is that, okay, whether or not the bail bondsman cancels that bond and reapplies it for the new bond, or, okay, you can take it up with in front of Judge McConicle this Friday.
That's one point, because we're gonna have to go through this and talk to the bail bondsman again. Because of the fact that he showed up, and I seen the video and Judge Taylor seen the video, and even with the video was insufficient. But because he's and he doesn't get that cash money that he put up back.
If that was dismissed, he should be getting, I believe, minus 10%. He should be getting his money back when he gets it back. But that is up to the bail bonds company. Okay.
No.
All right.
With all respect, Judge, you do when you use a bail bonds company, they take the 10% as their commission. You don't get that back.
Well, I can't take that, the one that was done, that was dismissed, the one that went in front of Judge Taylor, I can't take that bond and I cannot apply it to this case.
I understand, but I would ask,
okay,
if he put up that money and lost a great deal, and this government reinstating this for the third time, I would ask the court, he appeared on that bond, stayed at home, never got into trouble, would you just consider a $250,000 10%?
Okay, since he showed up, and this is the third time, I will make it $250,000, 10%. And I will also indicate that giving him still a bond redetermination.
Thank you very much, and everyone enjoy their.
Thank you.
You too.
Linda Jean Newton, ma'am?
Yes.
Thank you, Ms. Newton. I'm Magistrate Charte. Your criminal matter case number is 190-5617501. You have an attorney. Go ahead, Counsel Bird.
Yes, Your Honor, Brandon Bird on behalf of Linda Newton. My client waives her right to the formal reading, was advised to constitutional rights, so we stand mute.
Thank you. I'm going to enter plea of not guilty. Court dates are January 8, 2025, probable cause conference, followed by preliminary examination, January 15, 2025. Both matters are in front of Judge Jefferson. Counsel Douglas, this is from 2018. Go ahead, ask the bond recommendation.
Your Honor, Ms. Newton, the people aren't going to object to a $100,000 personal bond. We are asking for a tether and for her not to leave the state of Michigan. The report here would indicate that, at least at that time, she appears to have left the state with the child and gone to another state, even though there does appear that there was a court hearing that she failed to appear for, and then there was a court order allowing the father to have custody of that child. So, Your Honor, we do have concerns for flight given that. As far as prior, she had a 2015 aggravated DV. I do not know what the current status is for the family court matter, as that's not something I'm able to see. But given that there is apparently Ms. Newton not obeying a court order and then going to a different state, Your Honor, with the child, we do have concerns here for flight. That's why I'm not objecting to 100,000 personal if there's a tether.
Okay. Counsel, just so I understand, you have no new information, correct?
That's correct, Your Honor.
You know when, and so no new information, so you don't know if the case has been resolved in terms of she has contact with the child or anything that, correct?
That's correct, Your Honor. I did check the file notes and I did not see any information as to that. I do not know how she came to be in custody today. I don't know if maybe she turned herself in or if she just happened to get arrested. Perhaps she was in the state for the holidays. I'm not sure how she came to be in front of the court.
Counsel Bird, go ahead, please.
This is the kicker, Your Honor, and somebody really needs to clear this up for my client, and I hate to see the fact that she's in this situation. First of all, my client never lived in Atlanta. Address never lived in Atlanta. Doesn't have a daughter named Lyric Jackson. The only daughter that she has is 24 years old. Is 24 years old and isn't named Lyric. Because we're on YouTube, I don't want to put her daughter's name out here. But isn't named Lyric. It's impossible for this to be my client's case. Either somebody's using her identity or they're straight confusion. So we're gonna ask for a personal bond to allow my client to handle this outside of the court. Actually, it's becoming difficult. It's becoming difficult for my life's becoming difficult for my client because of this matter. Your Honor, she actually called the police because she was a victim of a crime. And the police ran her name and seen that somebody named Linda Newton had this warrant, and that's the reason why they took her in. But this is impossible. This is completely impossible to be my client, Your Honor. Doesn't know a Lyric Jackson. Doesn't have a daughter named Lyric Jackson. Never lived in Atlanta a day in her life. Has an address in Detroit. And her daughter, she does have a daughter, but her daughter's 24 years old now. So respectfully, we're going to ask this court for a personal bond, allow my client to at least figure out a way where this isn't in her name anymore. And so she could hopefully enjoy the rest of her Christmas.
Counsel, what's your middle name?
My middle name?
Her middle name.
Jean.
Okay, so we have a Linda Jean Newton and Miss ma'am, what is your name?
Linda Jean Newton. I believe I am a victim of Identity theft.
Okay, all right, hold on. DDC,
Yes, Your Honor.
can you tell me this person, Linda Jean Newton, has her fingerprints been compared? Because she's claiming identity theft.
She was fingerprinted, Your Honor.
But what would they
I'm
be
sorry, say that
compared
again?
to?
She was fingerprinted, Your Honor.
Okay, she was fingerprinted. And does her fingerprints match the 2019 case?
We have no way of knowing that here at Detroit Detention Center, Your Honor.
Okay.
That case was never arranged, Your Honor, so this might be her
Okay,
first
hold
time
on.
in the Detroit Detention Center.
Was it listed? What was her address? Or just give me the street number?
On this data information sheet, I have street number 383.
Okay. Is it out of Michigan?
No, Your Honor.
Okay. All right, thank you. All right, so we have an issue, whether this is Miss Linda Jean Newton. We have the actual person. We also have an issue that this is from 2018. We don't have any further information. Okay, whether this is Miss Newton or whether the case has been resolved. Ma'am, can you tell me just your date of birth? Don't give me the year.
322.
Okay. Okay, even though this is from 2018, we don't have any new information to indicate whether or not this custodial interference, if there's still a family court case involving, if this is the actual Linda Jean Newton in this case, she's gonna get $100,000 personal bond. I'm not gonna put a tether on her because this court is not aware of anything new as to whether or not there's still a family court case or not. And this court doesn't know whether or not this is the actual Linda Jean Newton that is associated with this case. So $100,000 personal bond. Ms. Newton, I suggest you go to court, handle this matter. If you don't, it will be placed and there'll be another warrant out for your arrest. You understand that?
I will be there. Yes, ma'am.
Thank you. Thank you. That concludes the matter.
Thank you.
Thank you.
That's all I have. Merry Christmas and happy holidays to you and your staff. We'll see you guys.
See you
Okay,
later.
Merry
Merry
Christmas.
Christmas. Merry Christmas, DDC. Thank you. Merry Christmas, everybody. Thank you. Have a good
All right.
Thank
day.
you. And we got Council Shive. Council Shive.
Yes, Your Honor.
You're here just for Merry Christmas?
Yes, good morning. Merry Christmas.
Okay, well, we're done. You have a good holiday.
Okay, you too. Thank you.
Thank you. Everybody have a good holiday. Bye.